Limited liability partnerships, or LLPS. Lots of acronyms here. Bar loves to test on limited liability partnerships. So, limited liability partnerships are a form of general partnership. How is it created? Just like a limited partnership, you've got to file with the state, pay that fee, and signatures are required. Otherwise, you're, guess what, operating as a general partnership. All right, so we've got some acronyms associated with limited liability partnership. LLPS, RLLP, LLP, RLLP. Okay, so, but just remember, a limited liability partnership is a type of general partnership in which you have to make those filings with the state. And you have to, just like a corporation, define it as the, Drayton and Sons LLP. Okay, a limited liability partnership is similar to a general partnership. It's governed by the same rules of disassociation, dissolution, and winding up, termination as a general partnership. And let's talk about something very important here. Many times we have a merger or conversion of partnerships. It's fairly common that partnerships may want to merge with one another, or partnerships might want to convert. So why in the world would you want to be in a general partnership? You wouldn't. So let's talk about conversion first. Conversion of a general partnership to an LLP. If it's not specified, it has to be a unanimous vote. General partnership to an LLP, unanimous vote. General partnership to a limited partnership, unanimous vote. Conversion, general rule, unanimous vote. You want to convert your general partnership to an LLP, unanimous vote. You want to convert your general partnership to a limited partnership, unanimous vote. Wrinkle, this may be modified by the partnership agreement, but the default rule is unanimous vote for conversion. Okay, when we talk about conversion, remember, general partners are always jointly and severally liable. So one of the advantages of conversion is that limited liability. Let's say we have a general partnership of 5 partners. And remember, a general partnership has at least one general partner and at least one limited partner. Some of those general partners want to become limited partners. They don't want to manage the business. They want to enjoy limited liability. They can do that. But they have joint and several liability for everything up to the date of conversion. Now, this makes sense. If our general partners are engaged co-owners of a business for profit and they have equal rights in management control, the ability to enter into contracts, and then suddenly they convert to a limited partnership, that does not give rise to, suddenly they're not liable for debts and obligations incurred before the conversion. It doesn't insulate them from liability. A general partner who becomes a limited partner is liable for all of the debts and obligations that they had as a general partner until the date of conversion. After the date of conversion, they enjoy that limited liability. Okay, another wrinkle. General partner in a conversion situation. If the third party reasonably believes that a general partner is still a general partner, they might be liable for those partnership obligations incurred to third parties. Remember the doctrine of apparent authority. So under apparent authority, If the general partner held himself out as someone who had the capacity to contract and the third party reasonably relies on that, it's possible that a court could hold that that general partner was liable for that partnership obligation incurred to a third party. Okay, so what's our conversion rule for consent? That's right, it's unanimous. You want to convert to an LLP from a GP to an LLP? Unanimous. You want to convert to an LP? Unanimous. You want to convert to an LLLP? Unanimous. Can this be modified in the partnership agreement? Yes, but that's our general rule. Our other general rule is that if a general partner becomes a limited partner, they have joint and several liability for everything up until the date of conversion. And under the doctrine of apparent authority, a general partner might be liable if they held themselves out to a third party as having the ability to enter that contract. That's going to be a fact-specific inquiry. Okay, let's talk about merger and conversion of limited liability partnerships. So partnerships may want to merge with other partnerships. That happens a lot. And what do we need here? Oh, yes, unanimous consent of all the general partners. What's our general rule for conversion? Unanimous consent. Okay, a limited partnership, the conversion rules will vary by jurisdiction, but just remember our general rule is that for merger, unanimous consent. All the property of both partnerships when they merge becomes the property of the new partnership. That makes sense. And what do we need to merge with another partnership? Well, there needs to be a plan of merger. And yes, we're going to need to make filings with the state that state the names of the two partnerships that are going to be merged, terms and conditions, and the status of the surviving entity. Okay, so is one law firm just being acquired or merging into an existing law firm? Well, whose name is going to be on that partnership? The state needs to know. Under what conditions, what terms, what status is that partnership merging? Or are we having two partnerships, two limited partnerships or limited liability partnerships merging and forming a new entity? Plan of merger, the state needs to know the name, terms, conditions, and status of the surviving entity. All right, as a last and final plug here, what do we need for conversion or merger? Unanimous consent. Unanimous consent is the general rule. If a general partner becomes a limited partner, and if the general partnership becomes a limited partnership or a limited liability partnership, joint and several liability for those general partners up until the date of conversion, unless there is some apparent authority situation. If you want to merge with another partnership, form a new business entity, or merge into an existing partnership, you're going to need to file that plan of merger. The state needs to know the name, the status of the surviving entity, and terms and conditions of the partners in the partnership. And property. When there's merger, all the property becomes property of the new partnership. And that is our lecture for today. Thank you for listening.